Hello everyone. In this presentation, the relevancy of facts under sections 12 to 16 would be discussed. Section 12 makes those facts relevant which help a civil court in determining the quantum of damages in the case of torts or contracts. Damage in civil law means an injury suffered by an individual, that is, the plaintiff, because of the wrongful act of another, that is, the defendant. Damages is the monetary compensation awarded by the court to the plaintiff to be paid by the defendant for the injury caused by him. The purpose for which the damages are awarded to the injured person is to compensate him for the injury suffered by him in such a manner that he will be put back approximately in a position in which he would have been had he not suffered the injury. Factors like the age of the victim, the nature and extent of the injury, medical expenses, loss of earnings, and physical and mental agony are relevant in quantification of damages by the court. Punitive or exemplary damages may be granted by the court in cases where the court comes to feel that not only should the victim be compensated, but the person causing the injury should be punished to deter the wrongdoer as well as others from committing such wrongful act, as in the case of defective food manufacturers and fraudsters, etc. In suits for damages, the amount is always a fact in issue and evidence can be given even under section 5 of any fact which will facilitate the court to determine this fact in issue. Section 13 deals with proof of right and custom. Right is a legally protected and recognized interest. The term right under section 13 includes tangible rights, that is, rights over movable and immovable property, and intangible rights, that is, intellectual property rights, public and private rights, proprietary, that is, ownership rights, and possessory rights, that is, rights of tenants, etc. It includes rights on one's own property like possession and ownership, as well as rights regarding others' properties like right of way, right to fish, etc. Custom, in order to give rise to an obligatory rule, has to be a long established practice or usage. It has to be repetitive, uniform, consistent, definite, and certain, and it must not be illegal, immoral, or opposed to public policy. Where the question is as to the existence of a right or custom, section 13 looks to two things: 1. Transactions, and 2. Particular instances which could throw light on the question. Section 13a, dealing with transactions, says that where the question is whether a certain right or custom exists, any transaction by which the right or custom in question was created, claimed, modified, recognized, asserted, or denied, or which was inconsistent with its existence, may be proved. Section 13b, dealing with particular instances, says that where the question is as to whether a right or a custom exists, particular instances in which the right or custom was claimed, recognized, exercised, or in which its existence was disputed, asserted, or departed from, may be proved. The term transaction means anything done by a person or between persons that would affect the rights of the persons. It can be bilateral, like a sale deed executed by the seller and buyer, or unilateral, like a will or a testament. Even a court's judgment is a transaction by which a right or a custom is recognized or annulled. An instance of which evidence is admitted is that which can be cited as an illustrative case or as an example for the purpose of proving the right or custom. For example, a deed conferring the right on A's ancestors is a transaction by which a right is created in favor of A's ancestors. A, inheriting from them, would be entitled to the right. If A's father had mortgaged the right to someone, the mortgagee is entitled to the right and not A, because the mortgage is a transaction by which right is created in favor of the mortgagee. If after the mortgage A's father grants the right to anyone and the grantee claims the right, the grantee will not be entitled to the right because the earlier transaction of mortgage is inconsistent with the subsequent grant. If therefore the question is whether the grantee is entitled to the right, the earlier mortgage would be a relevant fact to show that he is not. The section 14 again is one of the important sections that deal with physical and mental facts relating to a person. The section deals with facts relating to three aspects mainly: the state of mind, the state of body, and the state of bodily feeling. The basic principle of criminal law is that no act is a crime unless it is done with a guilty mind. In almost all offenses, guilty mind is an essential component. However, state of mind of the defendant may be relevant in civil cases also, as in the case of fraud, malicious prosecution, and negligence. Section 14 deals with different forms of mental condition like intention, knowledge, good faith, negligence, rashness, ill will, and goodwill towards any particular person. While intention, knowledge, negligence, rashness, and ill will are examples of mens rea of a person, good faith and good will are the elements that prove the absence of mens rea. Now, what are the means by which a person's state of mind can be ascertained? The state of mind of a person is impossible to prove by direct evidence. It can be proved either by person's own statements or by circumstantial evidence if the state of mind is manifested in one form or the other. Where the state of mind has to be established, similar acts, if they show the necessary state of mind, can be relied upon. If a person is charged with a crime, it is irrelevant to show that he committed a similar crime to show that he had committed the crime with which he is charged. But if it is shown that he did the various acts attributed to him, and the only question is with what state of mind he did them, then evidence of similar acts done by him could be given to show the particular state of mind alleged against him. The fact that a person has done a thing on another occasions is not usually relevant to the question whether he did it on the occasion in issue. But having shown by independent evidence that he did it, if his state of mind has to be established before the matter can be disposed of, then the fact of his doing similar things on other occasions will become relevant if they tend to show the state of mind. For example, where A is charged with shooting at B with an intent to kill him, in order to show that his intention was to kill B, evidence may be given that he shot at B previously. Where A is accused of receiving stolen goods, knowing them to be stolen, it has first to be proved that he was in possession of stolen property. But this is not sufficient to establish his guilt because it must be shown that he received it knowing it to be stolen property. To prove this knowledge, evidence can be given to show that he was in possession of other stolen articles, and it is unlikely that he received all stolen articles without knowing them to be stolen. The facts showing the existence of a state of body or bodily feeling can also be proved under section 14 of the Evidence Act. Where an action was brought upon a policy of life insurance affected on the life of the plaintiff's wife, and the plaintiff claimed insurance money on the death of his wife, the question was whether the assured was in good health at the time of effecting the policy. Evidence was given to show that at about the relevant time, she made a statement to a visitor in the course of casual conversation that she was in a bad state of health. This statement made by the assured herself as to her bodily infirmity was held to be admissible. Explanation 1 to section 14 states that a fact relevant as showing the existence of a relevant state of mind must show that the state of mind exists not generally but in reference to a particular matter in question. Now, when A is tried for murder of B by intentionally shooting him dead, the fact that A on other occasions shot at B is relevant as showing his intention to shoot B. But the fact that he was in the habit of shooting at people with intention to kill them is not relevant. Under explanation 2, the fact of previous commission of the offense by a person and the previous conviction of such person can be proved. By virtue of this explanation, evidence of the fact of previous commission of crime and previous conviction can be proved for a restricted purpose of establishing the state of mind with which he committed the crime in question. It cannot be used for the purpose of establishing that he had committed the crime. Section 15 deals with facts bearing on questions whether act was accidental or intentional. It deals with situations where the question is whether an act is accidental or intentional or is done with a particular knowledge or intention. Where the question is whether a particular act is done intentionally or occurred accidentally, the fact that the act formed a part of series of similar occurrences and in each of such occurrences the person doing the act was concerned is relevant. Now, when an act is repeated again and again, the chance of it being accidental is reduced. Where A is accused of setting fire to his house to claim insurance in respect of the house which he has insured, the fact that he lived in 4 houses and in each case the house was on fire and he claimed money from the insurance company is relevant to show that the fire in question was not accidental but intentional. So, in order to invoke the provisions of section 15, it has to be shown that the act in question forms part of a series of similar occurrences. The occurrences must be of a similar nature. There should not be a long interval between such occurrences, and the person doing the act must be concerned with each occurrence. The accidental or intentional nature of the act must necessarily be in issue in order to invoke section 15. Now, so far as the points of distinction between sections 14 and 15 are concerned, under section 14, all facts which establish any state of mind or body or bodily feeling are relevant. Under section 15, only where there is a question whether a particular act is intentional or accidental, the section comes into operation. The scope of section 15 is narrower than the scope of section 14. The condition for relevancy under section 15 is that there must be a series of similar occurrences in each of which the person doing the act must be concerned. Such a condition is not necessary so far as section 14 is concerned. Section 16 is based on the maxim, all acts are presumed to have been done rightly and regularly. Section 16 enables a party to prove the existence of a course of business to prove that a particular act was done. The expression course of business is not defined in the act. It implies habitual or professional avocation. Business in all public and private offices is conducted on certain settled lines, which means a certain course of business is followed in doing the acts. For example, official letters are dispatched from a public office after making an entry in the dispatch register. Where the question is whether a letter has been sent from the public office, the entry made in the dispatch register is relevant under section 16. This is about the rules pertaining to relevancy of facts under sections 12 to 16. Thank you.